Virginia Governor Abigail Spanberger just signed the most aggressive ghost gun ban in state history. And if you own 80% lowers, unfinished frames, or build your own firearms, what I'm about to reveal means you could be committing a felony under Virginia's new Chapter 532 law starting July 1st, 2026. By the end of this video, you will know the constitutional challenge and safety legislation. So let's get into it.
The Virginia Citizens Defense League, VCDL, immediately announced they're filing a constitutional challenge, arguing that homemade firearms have been legal since America's founding, and this ban lacks any historical analog under the Bruin framework. Governor Spanberger claims this is common-sense safety legislation, but gun rights attorneys are calling it an unconstitutional overreach that criminalizes a practice the Founding Fathers themselves engaged in. Hit that subscribe button right now because this Virginia law represents a test case for ghost gun bans nationwide, and how courts rule on VCDL's challenge will determine whether other states can ban homemade firearms or whether the historical tradition of self-made guns defeats these restrictions. Here's what just happened. In early April 2026, Governor Spanberger signed multiple gun control bills into law, describing them as common-sense steps that will help keep Virginia families, communities, and law enforcement officers safe. The centerpiece is Chapter 532, which makes it illegal to sell, transfer, or possess unserialized commercial firearms, unfinished frames and receivers, 80% lowers, and any firearm parts that can be assembled into working guns without serial numbers, collectively called ghost guns. VCDL immediately responded, "Homemade firearms have been legal since the founding of the United States. This law is unconstitutional because it has no historical analog under the Supreme Court's Bruin decision." Let me break down what Chapter 532 actually says and what it criminalizes, why Governor Spanberger's safety arguments don't match reality, VCDL's historical tradition challenge under Bruin, what Virginia gun owners must do before July 1st, the timeline for legal challenges, and what other states are planning. Number one, what Virginia's Chapter 532 actually says and what it criminalizes. The prohibitions. Chapter 532 makes it Class 1 misdemeanor, up to 12 months jail, $2,500 fine, to knowingly sell, transfer, or possess unserialized firearms, unfinished frames, true glass receivers, 80% lowers, or firearm parts assemblable into functional firearms without serial numbers. What unserialized firearm means, any firearm lacking federally required serial number. Includes commercially manufactured firearms with removed serials, already federally illegal, and personally manufactured firearms without serial numbers, now illegal in Virginia. What unfinished frame or receiver means, partially completed frames, receivers, readily converted to functional status, readily converted, per requiring only minor filing, drilling, or finishing. Clearly targets 80% lowers. Effective date, July 1st, 2026. No grandfather clause. Existing homemade firearms and 80% lowers must be surrendered, destroyed, or made compliant, serialized through FFLs. Exceptions. Licensed manufacturers, FFLs, conducting federal compliant business, law enforcement, and military. Antique firearms, pre-1899. Practically, if you own personally built firearms without serial numbers, 80% lowers, parts kits, 3D printed, you must serialize through FFLs before July 1st, or you're committing a crime. If you own unfinished 80% lowers, dispose or serialize. Possession alone is criminal. If you're finding this helpful, imagine what you'll learn in my next video, where I reveal the 5 states preparing identical ghost gun bans and the coordinated legal strategy gun rights groups are using to defeat all of them simultaneously. Subscribe so you don't miss it. Number 2, why Governor Spanberger's safety justification doesn't match reality. Spanberger's statement. Chapter 532, necessary to keep Virginia families, communities, and law enforcement officers safe. Implication, unserialized firearms pose unique threats. Reality, homemade firearms rarely used in crimes. FBI data shows commercially manufactured firearms with obliterated serials far more common in crime than privately made firearms. California AG report 2020 found only 1.4% of crime firearms were privately made. Criminals wanting untraceable guns steal them or buy illegally. They don't machine 80% lowers. Serialization argument. Proponents claim serial numbers help trace crime guns, but criminals building their own aren't buying from FFLs where background checks and paperwork create traceability. Serial numbers don't prevent crimes, they potentially help solve crimes after. Banning homemade firearms criminalizes law-abiding builders while doing nothing to stop criminals who already ignore all gun laws. Historical context. Americans built own firearms since before nation existed. Colonial gunsmiths didn't serialize. Founding Fathers didn't require serial numbers. Federal serialization not imposed until Gun Control Act 1968, nearly 200 years after Second Amendment. For vast majority of American history, Homemade unserialized firearms were norm, not exception. Quick legal note. This is educational information about Virginia's new law and constitutional challenges. This is not legal advice. If you own homemade firearms or 80% lowers in Virginia, consult attorneys about compliance obligations and legal options. Violations carry criminal penalties. Number 3. VCDL's constitutional challenge, historical tradition argument under Bruin. VCDL's core argument. Bruin, 2022, established gun regulations must be consistent with America's historical tradition. When examining modern restrictions, courts must find analogous laws from Founding Era, 1791, or Reconstruction Era, 1868. VCDL argues no historical analog exists for banning homemade firearms because such firearms were common, legal, and unregulated throughout American history. Founding Era evidence. In 1791, when Second Amendment ratified, most firearms were handmade by local gunsmiths or individuals. Serial numbers didn't exist. Idea citizens needed government permission to build guns would have been alien to founders. Many Revolutionary War militia members carried personally made or modified firearms. Reconstruction Era evidence. In 1868, when 14th Amendment incorporated Second Amendment against states, homemade firearms remained common and unregulated. Neither federal nor state governments required serial numbers, registration, or licensing for personally manufactured firearms. Ghost guns, as distinct legal category, didn't exist because all personal manufacturing was presumptively legal. Why serialization fails historical scrutiny? Serial numbers and firearm tracing are 20th century inventions. Gun Control Act 1968 imposed first federal serialization requirements 177 years after Second Amendment. Under Bruin, merely modern doesn't make it constitutional. Courts must find historical analogs. None exist for serialization. Textual argument. Second Amendment protects right to keep and bear arms. Manufacturing own arms is necessarily part of keeping them. If government can ban manufacturing, it can indirectly restrict keeping and bearing. Founders understood this. They didn't ban gunsmiths or home building because that would effectively nullify the right. Hey, 73% of people watching right now aren't subscribed. Join the 50,000 gun owners getting these constitutional challenge updates first. Subscribe, because when VCDL's lawsuit reaches courts, the ruling will affect ghost gun bans nationwide. Number 4. What Virginia gun owners must do before July 1st, 2026. If you own homemade firearms without serial numbers, 3 options. 1. Serialize through FFLs. Many offer serialization services, $150 per firearm. 2. Turn in to law enforcement. Surrender allowed without penalty before effective date. 3. Move out of state to jurisdictions where homemade firearms remain legal. If you own 80% lowers or unfinished receivers, 4 options. 1. Complete and serialize before July 1st. 2. Serialize unfinished receivers as is, some FFLs will. 3. Sell or transfer out of state before July 1st. 4. Surrender to law enforcement. If planning to build firearms, don't start new builds for Virginia completion. Law makes possession of unserialized firearms criminal after July 1st. Even serializing later creates risks because you possessed unserialized during construction. If part of VCDL's legal challenge, join VCDL, donate to Legal Defense Fund, stay informed about lawsuit timeline. If courts grant preliminary injunction before July 1st, enforcement may be blocked. Document everything. If serialize, keep FFL paperwork. If surrender, get written receipts. If transfer out of state, maintain records proving they left Virginia before July 1st. Number 5, timeline for VCDL's legal challenge. Initial filing. VCDL plans to file lawsuit in Federal District Court, Virginia by late April or early May 2026. Complaint will name Virginia officials, AG, state police, as defendants, arguing Chapter 532 violates Second Amendment under Bruin. Preliminary injunction. VCDL will simultaneously file motion asking court to block enforcement while case proceeds. Argument. Irreparable harm to Second Amendment if law takes effect July 1st. Court must rule before July 1st or law becomes enforceable. Possible outcomes. 1. Court grants preliminary injunction. Chapter 532 blocked. No enforcement until final decision. 2. Court denies. Law takes effect July 1st. Enforcement begins during litigation. 3. Court issues TRO, giving more time to brief. Trial and final decision. Assuming preliminary injunction decided by July 2026. Trial on merits, late 2026 or early 2027. District Court final decision either strikes down as unconstitutional or upholds. Appeals. Losing side appeals to Fourth Circuit. Briefing, oral arguments, 9 to 12 months. Fourth Circuit decision, mid to late 2027. Supreme Court. If Fourth Circuit upholds ban, VCDL petitions Supreme Court. If strikes down, Virginia petitions. Supreme Court could take case 2027-2028 term. Decision June 2028. Realistic timeline. Preliminary injunction May-June 2026. District Court late 2026, early 2027. Fourth Circuit late 2027, early 2028. Potential Supreme Court June 2028 or 2029. Number 6. What other states are planning and coordinated response? States considering similar laws. California already has ghost gun ban, similar to Virginia's. NY, NJ, MD, MA, IL, WA, or DE, considering or introduced legislation in 2026. If Virginia's law survives challenge, these copy it. If VCDL succeeds, bills likely withdrawn or defeated. Federal coordination. Biden administration's ATF finalized 2022 rule defining unfinished frames to receivers as firearms requiring serial numbers. That rule challenged separately in Vanderstock versus Garland. VCDL's Virginia challenge and Vanderstock are parallel legal battles, both arguing no historical tradition supports ghost gun regulation. Coordinated legal strategy. VCDL coordinating with other gun rights orgs, SAF, FPC, GOA, ensuring consistent legal arguments across jurisdictions. Multiple courts ruling on ghost gun bans using Bruin framework will influence each other, eventually reaching Supreme Court for final resolution. Stakes, ghost gun bans are a frontier of post-Bruin litigation. If courts uphold by finding historical analogs, gun control advocates claim victory and expand restrictions. If courts strike down for lacking historical tradition, gun rights strengthen nationwide. Virginia is current battleground. Here's the bottom line. Virginia Governor Abigail Spanberger signed Chapter 532 in early April 2026, banning sale, transfer, possession of unserialized firearms, 80% lowers, ghost gun parts, effective July 1st, 2026. Violations. Class 1 misdemeanor, 12 months jail, $2,500 fine. VCDL filing constitutional challenge, homemade firearms legal. Since founding, ban lacks historical analog under Bruin. Founding Reconstruction era had no serialization, no registration, no bans on personal manufacturing. Serial numbers didn't exist until Gun Control Act 1968, 177 years after Second Amendment. Virginia Gun Owners Act before July 1st, serialize homemade firearms through FFLs, surrender, or move out of state. Possession of unserialized firearms, or 80% lowers after July 1st, is criminal. Legal timeline, VCDL files April-May 2026. Preliminary injunction, May-June 2026. Critical, determines if law enforced. District Court, late 2026, early 2027. Fourth Circuit, late 2027, early 2028. Potential Supreme Court, 2028 to 2029. Other states watching. CA has similar ban. NY, NJ, MD, MA, IL, WA, or DE considering same. Virginia is test case. Subscribe, because I'm tracking VCDL's lawsuit through Supreme Court. Battle over whether Americans retain founding-era right to build own firearms, or states can criminalize practice older than nation itself. Thanks for watching. Next video reveals the 5 states preparing identical bans and the coordinated legal strategy to defeat them all.